Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, good morning, everybody. Welcome to the show. Today, our topic is key provisions of subject to transactions. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to follow us on Facebook. You can also follow us on YouTube. That would be the preferred platform. You can find us at INREM Podcast. That's at INREM Podcast. Subscribe, give us a like. We would appreciate it. A few announcements that we want to bring up before we get into the show. One, tonight we have our buy and hold meetup. So I'm going to let Sean give us an update. We've done this in the past, but for some of our new listeners, an idea what's coming tonight. Sean, what is the buy and hold meetup?
So the buy and hold meetup is designed for real estate investors who are interested in or actually purchase property for more of a long-term hold, whether that be Airbnb or traditional, lease. Multifamily is another area where buy and hold investors, the space that they're in. And then it's also attended by attorneys such as us. So there's, 3 or 4 different attorneys that are there. They're hard money lenders, property management companies, real estate agents, basically anybody who is interested in the, buy and hold investor space is generally going to be at this event. It's held on the last Tuesday of every month at the Scottsdale Area Association of Realtors, which is a great venue. And it's between 2 to 3 hours, depending on the length of the presentation. But basically, it starts at 4, and 4 o'clock is open networking. And they have food and drinks available. And it's free. You don't have to pay to come in and join and participate. And so during that 4 to 5 hour mark, though, our show is there, and we are live broadcasting or streaming from the event. And so what we do is we will interview the speakers for the night. We will maybe interview some guests that are there, as well as reserving the last half an hour or 15 minutes or so for questions for anyone that's there that has any type of question that they want to ask us. We'll take the question and do our best to, provide an answer. Tonight's topic is multifamily. And so there's 3 great speakers, prolific investors here in Arizona and outside that are in that multifamily space. One of the investors invests in raw land with the purpose of developing it for multifamily use. 2 of the other investors are looking to invest in and generally invest in already existing multifamily units. And they have a lot of knowledge. They do a lot of volume. So it'll be a great event. And I encourage everyone to come out. It starts at 4. Presentations start around 5:15. Come on out to the Scottsdale Area Association of Realtors. If you can't come out, at a minimum, watch us online from 4 to 5, as we're going to be talking to the guests. So you're going to hear a little bit about what they're going to be talking about. And then we're going to answer some real estate legal questions. And so it'll be a great event. Watch us online if you can't come out, but otherwise come out. It's free. And the more people, the better. So.
All right. Thank you for that. Another update. We want to introduce our listeners to the show to a new addition, our production assistant, Mayu Andre. She's here, and she's going to be helping us take questions from you. That's right. We're going to be opening up the show to questions that you have for not just us, but for our speaker, because at the end of the day, or our guest, at the end of the day, the show is really not so much about Sean and I, but some of the guests that we have on the show that are professionals and know what they're doing and have an expertise in a particular area that we're having them on. And so this is really an opportunity for you as a real estate investor to learn more about the topic that you have some interest in. So Mayu is with us. Mayu, are you there? Are you there?
I'm here.
All right. She's
Okay.
going to help us. So what are they going to be doing, Mayu?
So we are obviously live on our InRem YouTube and Facebook. So if you do have questions that you want, we're going to answer them at the end of the live show. So if you have questions, you can drop them in either the YouTube for InRem or, of course, where we're posting live on Facebook.
All right. And if you have those questions, you can post them in real time, but go ahead and start posting them now. So we have a catalog of that. And so we can begin to gather those. So with that, we're going to go to Sean, who has our legal update today.
Thank you, Andy. So today my legal update is the recording of memorandums or affidavits. I've covered this before, but I want to go over it again because I think it's appropriate to just kind of have a reminder as to when you can, at least here in Arizona, when you can record a memorandum or affidavit of a purchase contract, and to be careful not to record a memorandum or affidavit if you don't have the proper legal authority to do so. So in Arizona, we have a statute. It's ARS 33420. And that statute basically states that if somebody wrongfully records a document and they knowingly do so, that they can be on the hook for $5,000 in actual damages or $5,000 in statutory damages or treble the actual damages plus attorney's fees and costs. Another portion of the statute states that if the owner or equitable interest holder sends out a notice to the party that recorded the document or anyone named in that document, and they notify them, hey, this is a wrongful document and here's why, you should not have recorded this, and they don't release it within 20 days, then they're on the hook for $1,000 in statutory damages, treble the actual damages plus attorney's fees and costs. So there's pretty significant statutory damages, actual damages, attorney's fees and costs that can be awarded in favor of an owner against a party who wrongfully records a document against property. So the question is, okay, when can you record a memorandum? Well, that same provision or the same statute, ARS 33420 in subsection D, has a provision that states that unless you have a statutory basis or other legal basis allowing you to record a document, it is presumed to be invalid and wrongful. So then you have to look, okay, well, what does Arizona statute state? Is there a statute in Arizona that states that a buyer under a purchase contract for real property may unilaterally execute and record a memorandum? And the answer is no. In Arizona, there is no statute that allows for that. So then you have to say, okay, well, did they have a legal basis to do it? Well, potentially. And the way you establish your legal basis to record it is to have a provision in the contract that the seller executes stating that the buyer is allowed to unilaterally execute and record an affidavit or memorandum against the property. But if the contract does not have that, then you're not allowed to record because there is no statutory basis, and then you don't have your legal basis unless you go and actually have the seller execute the memorandum and affidavit, as well, and then you record it. But that's not in practice what happens. Instead, the buyer is the one that executes and has their signature acknowledged before a notary, and then they record the memorandum or affidavit of the purchase contract. But they can only do so if that purchase contract allows it. So in Arizona, we have the Arizona Association of Realtors contract form, the purchase contract. That contract is silent as to the recording of a memorandum. It's not going to say whether you can or can't. So if you've entered into a purchase contract using that contract, which is a great contract, it's been vetted by brokers and real estate attorneys, and they're always doing updates to it, and it's great. I mean, it does everything you need to do and more to purchase property. It protects, and it's more even-handed than maybe some other contracts. It protects both the buyer and the seller. Great contract, but it doesn't allow for the recording of a memorandum. So if you're using that contract to purchase property, you either need to add a provision there, or you need to use a different contract that allows, for the recording of the memorandum. So, be careful. I know that Arizona isn't unique with slander of title statutes and things like that. But I do know that here in Arizona specifically, that's the requirement. That's what you need. Other states may differ, but all states are going to have some, slander of title, either by common law or by statute, that you have to be very careful not to violate. Otherwise, you think, oh, well, great, I have this, contract, and I have the ability to purchase this contract, only to find out that no, you don't have that potentially. And not only that, but you now owe the owner, statutory or actual damages for slandering their title.
Well, yeah, when the real estate market was really heating up, there was this perception that I gotta just lock down this contract any way that I can, and there's also perception, especially in Arizona, the Wild West, right? It's slow to maybe having laws that govern this kind of stuff, and actually, with regard to this, it's not. You can't just willy-nilly go record stuff against another's property in cloud title. You're gonna run into all kinds of problems. So don't do it. All right, good legal update. With that, we're going to get into the topic or the subject today. We're talking about key provisions in subject to transactions. And with us today, we have Texas attorney T. Alan Keshker. Alan is the owner of the Keshker Group, Law and Title Professionals. And we really appreciate him being with us. Alan, thanks so much for joining us here on the show today.
You bet. Glad to be here.
Yeah, appreciate you taking the time to be with us. Now, Alan, I know you've been on the show with us before, and so to some of our listeners, this might be not new at all, but for others, it is new. So let's get into just kind of a brief outline of where you come from and what you bring to the table. Tell us about the Keshker Group, Law and Title Professionals.
Good deal. Yeah, so we're a law and title office. Primarily closing real estate transactions now. Have some attorneys that work with me and take care of the legal work, but I spend the great majority of my time messing around with the title side of things. And recently, we got involved in mortgage wraps back in 2007, 2008, very, very heavy because of the market. And we're seeing some similarities now in the market that's causing the mortgage wraps to become more popular and prevalent. So we're gearing back up and trying to educate everyone on what mortgage wraps are and how to do them legally in Texas and elsewhere.
Yeah, and I know on our last episode we have you, and we focus specifically on wraps. And one of the things you do with regard to wraps is the Wrap University. So tell us about that.
So I have a 4-hour course that we put on, and it's really from soup to nuts, everything from finding mortgage wrap transactions, structuring them, contracting, how to market for them, how to close them, and what to do post-closing to keep yourself safe. So it's really, like I said, a turnkey, deep dive into that, which we're going to turn into an online course here over the next month or so, and that'll be available nationwide.
So is this online course, is this kind of an extension of what you've been doing live with Wrap University?
Yeah, it'll be substantially similar with just a little bit more in-depth discussion on contracting and how to legally structure the transactions.
Very interesting. And when I know you said it, but I wanted to catch it again. When do you expect to roll that out?
It's scheduled for the end of February.
End of February. Okay.
Yeah.
And this would allow basically anybody in any state that is this beyond outside of the purpose of this to reach folks outside of the state of Texas, or just to reach folks in Texas more broadly?
So it'll have a strong focus on Texas law, but it is designed for national release in terms of trying to explain what these are. But if you're going to start closing these in other states, you do have to get a local attorney to assist there.
So let's jump into the topic today. And for those who have not heard Alan before, we're not going to get into the how do we define a subject to transaction or a wrap transaction. You can check out our older episodes on that. We don't want to relive that. We want to get into kind of the nitty gritty of what this looks like. So let's start a little bit deeper than the basics, but let's start with you as a closing attorney. What documents and information should a buyer obtain to assist an escrow agent or closing attorney with a subject to transaction?
So a lot of these transactions are very rushed because they're foreclosure files or what have you. But even if it's not a foreclosure, it's very good to at time of contracting get on a phone call with the borrower and the lender. They authorize you to speak on their behalf in this conference call and request the current statement, mortgage statement, a payoff of the current mortgage. If the mortgage is late, if the borrower or seller is late in their payments, you're going to get the reinstatement, and then also get a copy of the note. A lot of times people don't get the copy of the note. And for me, if I'm taking over the obligations of a promissory note, I want to know 100% about the note. And so it can't be, like I said, a lot of people just forget that, but it's a very important part.
Talk to me also about the core documents that make up a subject to transaction or a wrap transaction. What documents should a real estate investor looking into this be prepared to really have a complete transaction in your mind? So
historically, attorneys were advising that you can just get yourself a deed to secure assumption. I'm of a different mindset. I wanted a complete set of loan documents. So I want my promissory note, my warranty deed with vendor's lien. I want a deed of trust lien from the sellers, protecting the sellers. And there's a couple reasons for this. And there's also a bunch of disclosures and things of that nature. But I do want a full set of loan documents. And there's two reasons for that. One, it's going to allow that seller to potentially get a new mortgage because you can show the promissory note and the current payments or timely payments. But also it's if there's any type of dispute in regard to the transaction itself, it looks good that both parties are protected the same way that a Wells Fargo or a Bank of America loan is put into place. So I mandate it on all of my transactions. And if someone says they don't want it, then I'm not going to close them.
Hi, Alan. Thanks again for joining us. I actually had the chance to travel to Dallas and attend Rapp University, and which was just awesome. I consider you to be, basically the premier, attorney in the nation on these Rapp agreements, and so it was the information was invaluable. So any of our listeners out there, you have a chance to sign up for this online course. I definitely recommend it. Hey, I wanted to jump back for a minute, talking about the assumption deed, as opposed to, say, a promissory note and deed of trust, which is your traditional wrap, right? I mean, or promissory note and mortgage if you're in a mortgage state, but that's your traditional wrap transaction, which has been done for, I don't know, at least since I've been practicing, which is, going on 20 years now. Probably since you've been practicing, people have been doing these wraps. So it's, nothing new, although, nowadays we call it sub 2 and subject to, but it's a wrap. But you talked about an assumption deed, and are you referring to what a lot of investors call in the industry a performance deed, or a deed in lieu of foreclosure that's signed in advance of any type of default or failure to comply with the terms of the purchase contract?
So the deed in lieu signed in advance, has some struggles, in my opinion. The deed to secure assumption was actually just the conveyance document to sell the property. And the problem with it is it has no protections for the seller. So if that buyer defaulted and didn't pay the mortgage, seller could not recover that property. And with your full set of loan documents, obviously they can. The performance deed or deed in lieu of foreclosure is going to be a different animal. And sometimes people will sign those in advance to avoid foreclosure. I don't like them because they can be challenged as executory and not enforceable.
Yeah, and I kind of am of the same opinion. I mean, at the end of the day, if an investor is buying it and they want to sign in advance a deed in lieu of foreclosure, the only person that can really object to it is the investor buyer. But I do not like the idea of an investor doing a disposition, using a wrap, and then having the end buyer sign that deed in lieu of foreclosure, because that's when, because of course that end buyer is going to object probably when it comes time to execute on that deed in lieu. But what you're talking about is the assumption is, hey, I'm going to enter into a purchase contract. It's going to say that I'm purchasing it subject to, you're going to give me a warranty deed, and you're going to, as a seller, hope I'm going to pay the mortgage. And if I don't, maybe bring a quiet title action or something like that. But otherwise, you really don't have the remedies that, a traditional lender would have to, perform a non-judicial foreclosure or somehow, execute some way of forfeiting the buyer's interest in the property.
Yeah, and it was extremely common 20 years ago. Folks would just get that deed to. You have me? Okay. I don't think really any attorney who's working in this area is using that deed to secure. And they're drafting a full set of loan documents.
Yeah, and I think that is the right way to go about it.
Alan, let's get into talking about the purchase contract specifically, because it all begins really with the purchase contract. And let's kind of identify what you think are key provisions, because I think where this goes south with so many people is people jump into this and they go grab some form purchase contract, and then they go get involved in some exotic transaction that form didn't contemplate at all. But in your mind, to structure a subject to or a wrap transaction, beginning with the purchase contract, what we'd like to know is what you think are really some key provisions. And one of those, I think, probably just starts even with the purchase price. Are there key ways to set up how you structure the purchase price on how that's going to be in a subject to transaction?
So on a subject to where you're just taking over the mortgage and not paying an additional amount, or not going to have a promissory note that's larger than the existing one, there's some disclosure information. The purchase price also can't be an exact number because you don't know what the payoff is at the time. So I manufacture what I call a math word problem and say that the purchase price, first off, I tell them to go to the special provisions, paragraph 11 of the Texas contract. And then in paragraph 11, say that the purchase price is the assumption of the outstanding payoff of the mortgage at time of closing. And that gives us what I call a material term that's exact. So you can't dispute that. A lot of times you'll see people put to be determined or payoff or what have you. And in my opinion, those can be challenged.
How do you structure it in terms of setting out the purchase price when part of the purchase price is going to be the assumption and there's going to be an additional sum that goes to the seller after that amount?
If it's just a sub to where you're paying some dollars to pay off the seller's equity or what have you, then the same way that we discussed. However, if I'm taking over the property and the seller is taking a seller carryback, well, now we're back over to the mortgage wrap transaction. I've seen people lately, in my opinion, get confused and they say, well, we're taking the property subject to, And also there's an additional seller carryback note. What they've done is they've dissected a mortgage wrap into its two parts. And so if it's a bigger note wrapping around the existing note, you're using the seller finance addendum in the contract. If it's a note taking over the exact amount, then you have the assumption addendum and the contract.
Alan, one of the things that I took away from Wrap University was the fact that in Texas, you guys use a lot of the state forms to do, wraps and subject twos. In Arizona, we could if it were for straight seller carryback, but in my opinion, the form, probably doesn't. The seller financing addendum generally doesn't contemplate subject to. But what do you think about investors in Texas using like their own purchase contract? Does that create problems, or do you like to just say, hey, go with the tried and true, Texas form?
So we try to direct everyone over to the Texas form. And in Texas, we actually have an assumption addendum that's promulgated by the Real Estate Commission. It's hit and miss. We have to amend it a little bit. But people ask, well, gosh, are mortgage wraps legal? And there's, Texas legislation that governs how they're to be closed and what disclosures, et cetera. So our forms lend themselves real well to using those. I don't like all these purchase agreements, these 2-pagers, 3-pagers. There's also floating around big old giant mortgage wrap addendum that I think is extremely over-inclusive and not needed. You can cherry pick some of the items out of these big giant addendum, but I would suggest not using them, the ones that are floating around.
Well, let's talk about that and an addendum or disclosures. I believe you mentioned that your documents and your subject to documents or addendum in particular has, 19 or 20 different statements in it saying, hey, your loan's not being paid in full. Hey, it's still going to show up on your credit. And, all of these different disclosures that the seller signs off on. And then, if something goes south, you have it, what's called, I think, like the 20 disclosure letter or something like that.
Yeah.
Talk to us about that and those disclosures and what document you use for that.
So, doing this for so long, there are situations where, and I, usually I think it's seller's remorse, and they'll say, hey, I didn't know that they weren't going to pay off my mortgage. So if you're using all the documents that I suggest you use, there is, I call it 1911. There's 19 disclosures, and it's signed or initialed 11 times. And so the main reason for that is just to make sure the parties are educated, but also it's some security if someone wants to allege that they didn't know this was going to be a wrap transaction. They'll go find the lawyer, and invariably the lawyer will say, this is fraud. And then I send my letter, and that's the last I hear of that lawyer.
Yeah, it's hard to argue with 19 disclosures and 11 initials and saying, well, nah, that's not what I agreed to. Oh, really? Okay. So very cool.
Alan, sticking with the purchase contract still, I'm curious, how do you handle or like to handle assignment provisions, and what language do you use or like to use to allow a contract to be signed? Because one of the things Sean and I have gone back and forth and talked about assignments, because just legally speaking, and as a technical assignment is very easy to do. It's easy to go get a form that just in whole cloth assigns all right, title, and interest to in and about anything you can think of in just about a paragraph. But sometimes in some of these more complex transactions, you don't want just that, and there's a way to go about doing that. How do you like seeing that and like to see that in your forms?
So I suggest that folks up in paragraph 1, by the buyer's name, put and/or assigns without consent of seller. But also I suggest that they put in our special provisions paragraph that it is the intent of the buyer to in fact go and assign this to a different end buyer. And what we're trying to do there is get away from a situation where a seller is confused and thinks, well, if I'm not selling my property to person X like I contracted, then I don't have to close. And so we're trying to nip that in the bud before it happens. And it is, relatively often that a seller will get confused and say, I contracted with Alan, and Alan's not buying this, therefore I don't have to close. So I like it in paragraph 1, and then also in the special provisions paragraph. And the actual assignment document is a 3-page document that tries to take care of all considerations of the parties, of the assignor and assignee.
Alan, I have a question specific to Texas. You mentioned reinstatement and the fact that, hey, a lot of these subject to transactions are going to be, distressed properties where the buyer needs to come in and rescue it. And there's some states, I know Colorado in particular, and I think Oregon and Washington have foreclosure rescue laws in place. And one of the key provisions of those foreclosure rescue laws is any purchase contract that where the loan is in default and it's going to be purchased subject to, and the buyer's going to, provide assistance on, they have to provide a 3-day right of rescission. So the contract signed, and you have three days to basically consider, the seller has 3 days to consider whether or not they want to go forward. And if they, rescind during that time, it's over. Even if the buyer's, gone and reinstated the loan, it's over. Does Texas have anything similar to that?
So not the 3-day, but with the new legislation, there's what we call 5016 disclosure. It's Texas Property Code 5.016, and it's really just all of the nuts and bolts of the mortgage, taxes, and insurance on the property. Once that notice is given, that disclosure is given, the buyers now have sellers now have 7 days to rescind that transaction. So it can become problematic because a lot of times we're closing file in less than 7 days, and so the legislature, I don't know, in their wisdom, they instead of saying, okay, it's 7 days from the date you get it, it's actually 21 days if it's fewer than 7 days. I don't know why they did that, but it is extremely problematic. And so when we close a foreclosure transaction, we're once we close, we don't fund and disperse on that. That reinstatement gets sent up to the mortgage company, and then we stand down and wait until we have written confirmation that the foreclosure did not occur. And that also gives us some time for the buyers and sellers to cool down.
What happens if the buyer sends the reinstatement and the seller decides during that 7-day period that they don't want to do this anymore? What happens to that reinstatement amount?
So if anyone's going to be paying a reinstatement and we haven't conducted the closing, we get a copy, we get a deed, a warranty deed. We call it a deed to secure the buyer. And then the closing will formally occur. We've had situations where sellers, kind of savvy and say, oh, you paid my reinstatement. Good. I'll come free. I'll keep the property. And that deed has been recorded. And then the seller is usually owed money, and they realize, well, I'm not getting any money and I've lost my property. So perhaps maybe I will come and close.
Mm.
Alan, I want to move to the subject to addendum. And you just gave us just a few minutes ago how often you require, signatures noting that and how many times you've disclosed and how many times people have signed off stating that they understand what they're reading, so on and so forth. And anytime there's an addendum to a contract, this should cue a real estate investor into the idea that it wasn't sufficient to just deal with this in a quick paragraph in a contract. We needed a separate addendum. So obviously this disclosure requirement is monumentally important for a subject to transaction. So why don't you kind of give us the full scope of what you think are key provisions in a subject to addendum and what it is that in your mind needs to be disclosed?
So, well, first off, everything that the legislature said we need to do, we need to do. The penalty for not following the statute is rescission. as well as monetary damages. So unlike the SAFE Act, Dodd-Frank Act, Texas SAFE Act, there's teeth in this one. And so that 501(c) disclosure and also an insurance disclosure are the two main ones from that Senate Bill 43. In my addenda, I'm letting everyone know this is a mortgage wrap transaction. Mortgage is not going to be paid off. There is a due on sale clause in the deed of trust in regard to that mortgage. The lender may call the note due, and if so, I have provisions in there how the parties are going to work with each other to resolve this. Another agreement that I have, in addition to the authorization for right to talk with the mortgage company and a power of attorney, we have an agreement to reaffirm in the event that there's a bankruptcy filing by the borrower or seller. And so it's just a written agreement that says the seller is going to reaffirm the mortgage, so that you don't have to go and hire your own bankruptcy lawyer to come enforce that if it does occur. Those are the main ones off the top of my head.
What about what documents do you like to see in addition to help facilitate the closing? Do you recommend authorizations to release informations, power of attorney, assignment of insurance proceeds?
Yeah, so you have to consider the situation where the seller is no longer available at all, and so you need to have 100% access to that mortgage company. So we have our authorization, and then I beef up the authorization and make it a notarized power of attorney. That power of attorney also talks about the return of escrow funds and also payment of any insurance claims, and allows my buyers to actually sign off on behalf of the sellers on those checks when needed. And it will occur in almost every situation where that mortgage is being paid off and there's going to be an escrow refund. So those two documents, and I think that's it in terms of access to the mortgage company. But you have to consider that you're going to need access to that mortgage company. All your mailing needs to come to you as opposed to the seller. Any phone calls that are going to be made about defaults or what have you are going to come to you. So you're changing all that information with the mortgage company at time of closing.
Let's talk about the promissory note, an important piece to a subject to transaction. If I go into Google and I download an average promissory note, I'm probably going to be okay in Texas, right?
Probably not.
Oh, that's what I thought.
The nuts and bolts are all the same. I've embedded things in my note and deed of trust that will allow for release of any lien interest in the event the seller is not available. And so it's common that you have the sellers scurry off to whatever they're going off to do, and you don't have them available anymore. I've got some other provisions in regard to handling situation if the note is called due, what the parties are supposed to do, how they're going to work with each other. So you can download a promissory note and you can have all of the items that you need in there in terms of payments being made. It's just not going to have some of the special stuff.
Alan, you talked about the situation where a seller who receives a note and deed of trust or mortgage, they become unavailable. And I've, throughout the years, done a lot of title curing work. And that's a very common thing, both. And unfortunately, it's just not individual sellers. It's, institutional lenders that have disappeared, filed for bankruptcy, had receivers appointed, whatever the case may be. And then, you contact them and say, hey, my client paid this loan off years ago. You never released. Oh, what? We have no record of that. You have no record. We're happy to take the checks, but you have no record now, and so, it's always a difficult thing. And there's procedures that allow for an expedited release here in Arizona in those types of circumstances. But what role would a servicing agent play if you decided, hey, I'm concerned that the seller may disappear, and when I pay this off, I'm not going to end up with this release of this deed of trust that I'm going to need released in order to, sell the property, and or have it, own it free and clear. What role could a servicing agent play, if any, in that?
And you're talking about third-party loan servicing company?
Yeah. So if I'm concerned that the seller's going to disappear, would it be beneficial for me as the buyer to put a servicing agent in place, maybe escrow the deed of release and reconveyance, so that, if it does get paid, then the servicing agent, who presumably isn't going to disappear on you, would be able to just record that document?
Yeah. So we used to do that. We would have that release drafted up and held in escrow. What I've done now is embedded in my note and deed of trust that if you pay off the Wells Fargo loan or what have you, the one that we wrapped, then simultaneously when Wells Fargo releases their lien, that releases the seller's lien interest. And so I've moved away from having those escrowed items, mainly because third-party loan servicing companies do go out of business. And so now we're wrestling with who's going to keep that document.
So how, this is the first time I've heard of this strategy. This is incredible. And this type of language. So, how have subsequent title companies handled that, where you've said, hey, the release by Wells Fargo is also a release of this deed of trust, so we just need one release, we don't need two? Have you closed subsequently to that taking place? And, have you had to educate some title companies on that in, future transactions?
Yeah, and I'm smiling because it's incredibly astute of you to know that that's not going to be something that just willy-nilly they're going to accept. So I call it a arm wrestling match when we in fact do need to utilize that clause. I have to go and educate the underwriter, and hopefully nicely get into a conversation where it's all a matter of managing risk. And so they need to understand that this release by this seller that we took the property sub to, it's risk-free. I mean, that seller isn't going to be owed any money. We have the documents that show they're not owed any money. So it's a wrestling match. I've won them all so far, but I can see where we can run into, Fidelity looking to be risk averse and say, no, that's neat, Alan. We like your language and all, but no.
Yeah, there's what the law provides, and what title companies are willing to insure, and they're not always the same thing. So,
yeah.
Alan, I'm curious, just as kind of a follow up to what you mentioned before, as having the seller agree to reaffirm the debt in the event of bankruptcy. And for those of us who just maybe are creditor lawyers or just barely play around in bankruptcy, our understanding is that, the bankruptcy at the filing, stops all debt and everything else. Has there been any litigation that you're aware of in the federal courts or bankruptcy courts in Texas or anything else that have recognized the obligation to reaffirm the debt, or is that a settled issue, I guess is
the answer to that's no. And my document is more educational in nature.
Sure.
We're asking them, please do the right thing. I do think you'd be successful going into bankruptcy court and forcing the reaffirmation, but that's what we're trying to avoid.
Yeah, transactionally, I don't know why you can't. I think it's awesome. It's an awesome provision. I'm just curious whether that's been whether they've litigated that or interesting. What about other provisions in the deed of trust, mortgage itself, key provisions that you don't typically see in a standard deed of trust that we need in a subject to transaction?
So mainly we're going to see, I think it's 2 or 3 times in the deed of trust where we're talking about that mortgage that's going to stay in place. And the typical investment strategy is take a property subject to, and then you immediately go seller finance, wrap that to a third party. And so now we're having to include that assumption language in the deed of trust that we're now drafting up simultaneously for the end sale. Trying to think what else in the deed of trust is not typical. I always suggest that people have their end buyers escrow their tax and insurance payments. I don't want to trust my end buyers to save up that money for the entire year and then make that payment. And I don't want anyone in that situation. I want my mortgage wrap transactions to succeed. I always suggest folks are very, very nice foreclosing lenders. If they do have to go and recover a property, they try to go through loss mitigation efforts. But I don't think any of those items are necessarily in my deed of trust, other than the items that we discussed.
All right, so we have some questions from the audience for one of us, or probably for Alan. So Mayu, why don't we go to you? What questions do we have, and who are they from, and who are they for?
Yeah, so this question is actually from Yvette watching from Facebook Live. So thank you, Yvette, for reaching out to us. This question isn't directed to anyone in general. The question is, how is the due on sale clause handled in a sub-2 transaction?
Let's let Alan answer that, because I know from attending Rapp University, he has a good answer for that.
So in the event that, well, first off, the times that, if you want to look at the percentage of times that we've had the lender call the note due, it's 0.000005 of our transactions. So obviously not very common, but we have had it in a few situations. And what we do is we deed the property back over to the borrower and show that deed to the lender. And simultaneously, we're getting a deed right back over to the end buyer. And we've used that on 3 occasions, and it's worked every time. The lenders don't go back and start doing title searches in a month or 2 or 3. So far it's been successful. I call it kind of a little cat and mouse game, and we haven't been caught at it yet.
Well, and the reason why you can do that, Alan, is because the original loan documents state that if there is a default, other than a monetary default, right, other than a failure to make payment, that the lender has to serve a cure notice. But at least, of the hundreds of deeds of trust and notes that I've reviewed, I've not seen provisions saying, but we, are limited on the number of times that, you can cure. I mean, the borrower can cure indefinitely.
Right.
So it basically says, if you cure in 30 days, then we're set. And then if you breach again, and it's a non-monetary breach, we send you another cure notice. So basically the borrower can just keep, doing this cat and mouse game like you described, pursuant to the provisions of the loan documents, right?
Yeah. And on every single occasion, I secretly hope that the bank sees what we're doing. And the reason is because I'm going to let them know we're going to continue doing that. And they can't stop us. So let's get into a discussion on having this a qualified assumption of the mortgage. But like I said, no lender has seen it, and so we haven't started that conversation yet.
Now, in the you mentioned it, but not. I don't know that you referred to the due on sale clause. You talked about assignment and assumption. But let's say that investor enters into a subject to wrap transaction, and they take title, and a common disposition method is they're going to go and do another wrap. So they're going to wrap the wrap. So you're going to want, though, in the original note and deed of trust to have a provision that that note and that deed of trust will not be due on sale, correct?
So when I go and seller finance to a third party, my sub-2 documents do not have a due on sale clause, and so we don't have to get consent to sell. I do craft in a due on sale clause with my end buyer, and really just because I want to know. I'm never going to say no, you can't sell the property. I want two people liable for that note, if not more. But I do put that due on sale clause on my sale or disposition of the property.
So there's no due on sale clause on the note and deed of trust given to the seller for the original wrap, but then when you dispo it, you're going to have a due on sale clause in the note and deed of trust that's signed by the end buyer.
Yep, exactly.
We did have a follow-up question. So we also had Damon asking for our previous question, is this possible if they have passed away?
Is
Due on sale?
due on sale. Alan, you want to take that, and then I'll chime in because I kind of have some thoughts on that as well, in light of some federal law that governs that.
Yeah. So the only mortgage that's going to have a due on sale in the event of borrower becoming deceased is going to be the reverse mortgages. All the others, and I actually will tell people in some of my disclosure documents that if the borrower passes away, then nothing changes. Heirs are going to be receiving the payment. The promissory note's still in force. The payments, strictly speaking, go to the estate. So we've never had a problem other than just educating the heirs. Hey, my dad passed away. I see that there's a note, and we just have to educate them. Yep, have a note. We're going to continue the payments. Everything's fine.
Yeah. So there's a federal statute that deals with residential mortgage loans that basically states certain circumstances that occur for which the lender cannot invoke the due on sale clause. Regardless of the language of the due on sale clause, they can invoke it. One of which is a conveyance to heirs after the borrower passes away. So you can, if you have heirs that want to basically take title to the property and hold it as, an income producing property, then they can take title to it. And as long as it's not a reverse mortgage, the lender can't invoke the due on sale clause. Now, if those heirs, and I think this is what the question is getting to, if those heirs want to, the heirs or the executor or personal representative, we use the term personal representative in Arizona it's the same as executor. But if the personal representative, executor, or heirs later want to convey it to a third party, even if it's subject to with a wrap, then you are at risk of a due on sale violation. Is that your understanding as well, Alan?
Well, you say the heirs wanting to sell. I was under the assumption we're talking about my sub 2 acquisition with that seller passing away.
Oh, I see. Yeah, so it's already been done. Is that? Yeah.
Yeah. And so we, sometimes we educate, and then I'll even. There's been an occasion where I've assigned and transferred the note and deed of trust over to the heir, just to make them feel a little bit more comfortable.
Yeah, so let's talk about that. So we'll set it up a little bit here. Let's say that you're an investor, you've purchased from a seller, and everything's going smoothly for a year. You're making the loan payments, and all of a sudden you receive notice, hey, this seller has passed away. Now, the due on sale clause is the due on sale clause, and the lender could still invoke it at any point. That's not changed. But let's talk specifically, though. What if the heirs are like, well, I don't want to do this. I don't want to be in this agreement anymore. Or the personal representative or executor of the estate's like, no. We don't want to do this. Could the heirs or personal representative unwind that transaction after it's been in place for a year?
I don't want to instantly say no, but I'm inclined to think that contractually speaking, I'm the owner of that property and I have an obligation to pay that mortgage. Just because someone passes away, it doesn't change any of that.
Right.
So, always kind of tongue in cheek say, I've never had a deceased borrower worry about that item on their credit reporting. They just don't care.
Yeah. So essentially, and I'm with you. I mean, you never say never because that's not the way the law works, right? There's always exceptions, and generally yes, and those types of answers. But um, my understanding, at least from probate here in Arizona, is that interest in the real estate would no longer be a fee simple interest because it's been sold. It's gone. It's sold a year ago. However, the estate would still have a personal property interest, which is the ownership of the note. The estate holds the note. And so at that point, then you would distribute or assign the note out of the estate to the heirs, in pro rata based upon their percentage of inheritance. And then each of them would, have the right at some future time, if, payments aren't being made, they could then, as assignees of the note, they could then go and enforce the payment obligations on behalf of the deceased seller / now lender, for that matter.
Yep. Yeah, no, exactly. When it's a sub two, a lot less importance being placed on this by the heirs. If it's a mortgage wrap purchase where that estate is owed additional dollars above and beyond that mortgage payment, then they're a little bit more interested. But we, so far we just haven't had any issues that haven't been able to be, explained and resolved.
Right.
Alan, I have a kind of a final question here. I know we're getting close to time, but I think it's such an important one and a basic one, but nobody ever talks about it. And that's, how do you like to structure property insurance on this deal with all the parties in a seller subject to or a carryback transaction like that? How do you like to structure the property insurance?
So step one is you've got to get someone who's familiar with getting insurance in place on mortgage wrap transactions. It can't just be willy-nilly any insurance agent out there. And what they do is the seller is going to cancel their insurance. Buyer is now the owner of the property, so they have to be the insured. They're going to purchase insurance, and then they're going to list that seller as an additional interest, as well as mortgagee clause, because they're a lender, strictly speaking. But what the mortgage company wants to see is their borrower's name on there. And we used to do an additional insured, but now they're utilizing just an additional interest, and it's working for us so far.
All right, Alan, thanks so much for being with us. Tell us and our listeners where they can find you, how they can connect with you online, social media wise.
You bet. So just scoot over to our website. It's just my last name, Cesker.com. So CESHKER.com. And then you can find our email address. We have a mortgage wrap and subject to community on Facebook that we're building in conjunction with our Wrap University. So you can follow that. But go to my website, Cesker.com, and that's the best way to get in touch with us.
All right. Well, thank you so much for being with us, Alan. Look forward to having you on again.
You bet. Thank y'all.
Thank you, Alan.
All right. With that, everybody, thanks so much for being with us. Make sure to join us next week. Again, we're going to be taking live questions every opportunity that we can. So it's important for you to join us live. And if you can't join us live, leave us a question in the comments section of the episode on whatever platform that you use. That's important. That allows us to take those questions and read them, even if you're not able to be here live. With that, we'll see you all next week.
Have a good day, everyone.